California's lemon law has changed in a big way for 2025. In this video, we'll cover California's new lemon law process from start to finish, including who has lemon law rights, what kinds of repairs you need to have a good case, and the different ways to make a lemon law claim under the brand new lemon law for 2025. Make sure to watch until the end when I'll share how you can avoid the biggest mistake I see people make in their lemon law case. My name is Sina Rez Law. Not only am I a huge car fan, I'm also the founder of Sina Rez Law, a California lemon law firm specializing in lemon law. Every day I go to war against the world's biggest car manufacturers on behalf of people just like you. If you're new to the channel, make sure to subscribe for all of my lemon law tips so you don't get taken advantage of by car manufacturers and to help you get the most money possible. Before I do anything, I like to state the goal. And the goal in every lemon law case is to get the consumer, the plaintiff, these are different names for people like you, out of a defective car and to recover as much money as humanly possible, as quickly as possible on their behalf. In lemon law terms, we call this a repurchase or a buyback. Sometimes the settlement doesn't include the car going back to the car manufacturer, and we call that type of settlement a cash and keep. It's not always easy, but this is what I love to do, and I have a great team of attorneys and support staff that make these big wins possible for our clients. Let's talk about who can qualify. You really need to check 3 boxes to be able to potentially qualify. These mostly have to do with how or where you got your car. Number 1, did you get your car in California? California's lemon law requires you to have purchased or leased your car from a California dealership. Private sales or transfers or out-of-state sales are not covered by California's law. If you got your car out of state, it doesn't mean that you're out of luck. You may qualify under a different state's law, even if you don't live there. The second requirement is something new for 2025 based on a recent California Supreme Court ruling. Your car needs to now come with an express warranty at the time of sale. What the hell does that even mean? It means your car needs to be leased or purchased new or certified pre-owned. A CPO car is usually a lightly used car that the dealer and the manufacturer basically claim is like new. Although in my experience, that's marketing fluff. What's really important here is that used cars that are not CPO will usually no longer qualify in most circumstances. And number 3, you need to bring your case within 1 year of the expiration of the applicable warranty and within 6 years of the original sale of the car. This is another new requirement for the 2025 law. Now that we've talked about some of the barriers to entry with the lemon law, let's talk about how to actually qualify. Your car needs to have problems. The newer your car is, the more problems you have, the stronger your case will be. At a bare minimum, the lemon law says that you need to have at least 2 repair attempts. Despite this requirement, we still have many successful cases with just 1 repair, but that better be a damn good repair for something serious. Most people think that you need to have a specific number of repairs, like 3 or 4 repairs, but that's not really true. What you need is an unreasonable amount of repair attempts. It takes some experience to judge what exactly that means, but here's how I've successfully done it. I go through each and every repair record and I look to see what complaints you made, whether they were verified or duplicated by the dealership, what parts they're fixing and how critical they are to the car functioning safely, how long the repairs took, and whether you kept coming back in for the same problem over and over again. I also look to see what make and model vehicle you have because some manufacturers are a real pain in the ass to deal with and they'll fight tooth and nail if you don't have the clearest case. Other manufacturers are much more lenient and will go the extra step to settle a case. If you think there's a chance that you may qualify or maybe you're not sure, I strongly suggest that you reach out to us using the link in the description. We will review the documents you share with us completely for free and give you our honest opinion on your case. Assuming you have a good case and you're working with our firm or another lawyer, usually at this point, they'll send you an agreement to sign. We call this the retainer agreement, but there are a bunch of different names for this. The purpose of this agreement is to make the relationship as attorney and client official. The retainer agreement is going to list all kinds of standard stuff, but it will also discuss how the attorney's fees are handled. So it's incredibly important for you to read it and to understand it. I'll discuss the topic of attorney's fees in a different video, but here are the basics. Most law firms will not charge you any costs or fees to represent you in your lemon law case. However, if a lawyer helps to get you more than your money back, usually there'll be some sort of splitting of this bonus amount that we call a civil penalty. You will usually see the civil penalty split as a percentage in the retainer agreement. Make sure to read that and to ask any questions if you're unsure in which circumstances it applies. After signing the agreement, it's time to start working on your case. We usually do this in one of 2 different ways. The first is by filing a lawsuit. This is the most common approach. And the second is by sending a pre-litigation or pre-lawsuit letter. However, I strongly recommend against doing that because you don't pay any lawyer fees and it's so easy to get taken advantage of. So if you decide that you need some help, then use the link in the description. Like I just mentioned, filing a lawsuit is always our plan A. This is because it's the most aggressive approach in starting a new case. It's expensive for a car manufacturer to defend a lawsuit, and there's all kinds of rules and deadlines that both sides have to follow. The car manufacturers, They don't like this. I'll cover the lawsuit process in more detail in another video. The downside is that the litigation process can move slowly at times, but good news is that the lemon law has changed in a major way for 2025, and a lot of changes are meant to move cases along much faster. If you haven't watched it already, be sure to check out my video on the 3 biggest changes to California's lemon law for 2025. A different approach would be to start the case by sending the car manufacturer a letter instead of filing a lawsuit. So why would we do this? Well, the new lemon law has a lot of rules on how car manufacturers have to handle these letters and how quickly they need to make offers. If the car manufacturer doesn't handle this letter precisely the right way and they don't make an offer quickly enough, then we can file a lawsuit and ask for even more money back. We call this extra money civil penalties. And now let's talk about settlement. After your lawyer and the car manufacturer have had time to investigate the case, we can usually reach a settlement without ever having to go to trial. There are 3 different types of settlements in lemon law cases: a repurchase, a replacement, or a cash and keep settlement. We'll touch on all 3 of these. Let's start with the repurchase. In a repurchase, the car manufacturer has to buy the car back from you. The amount of the buyback has nothing to do with the current market value of the car. Think of this as more of a refund of your money. So the more money you spend, the more money you get back. But the car manufacturer is legally allowed to take deductions for things like the miles you drove before your problem started, any money you owed on a trade-in, and dealer upsells and add-ons like paint protection or gap insurance. The manufacturer has to pay off your loan and pay your attorney's fees. Another settlement option is to get a replacement vehicle. Imagine you had a 2023 Chevy Silverado. If GM agrees to a replacement, then you get upgraded to the latest year Silverado. If you get any extra options, you're responsible for paying the difference. If you have a loan, you keep making your exact same payments as you were making before. This can be really great if you liked your car and you had a good deal. The problem is that we can't force the car manufacturer to offer you a replacement, and in my experience, they rarely do when a lawyer is involved. The loan is not paid off since it's still active, but the car manufacturer has to pay your attorney's fees just like in a repurchase. The last settlement option, which is fairly popular, is a cash and keep. This is where the manufacturer doesn't take your car back. They don't give you a replacement, but they do write you a check. We may go through this route if you actually prefer to keep your car, which some people do, or if your case isn't quite as strong as a standard repurchase case. In this case, the car manufacturer is still paying your attorney fees, but oftentimes they combine it into a single check made out to you and the attorney. No matter what type of settlement you get, your case will begin to end with the signing of a settlement agreement. If you have a lawyer, they'll make sure to review the agreement to make sure there are no sneaky terms that don't belong in there. If your case settles for a cash and keep, then there's nothing you have to do after signing the settlement documents other than waiting for your check to come in. If your case ends with a repurchase, then there's one last step. We call this the surrender. The surrender is an appointment to return your car to an authorized dealership. The new lemon law says the car manufacturers need to have your check ready for you at the dealership, so you can simply sign some more documents and trade your keys for a check. For older cases, depending on the car manufacturer, they may send your check to your lawyer's office, who will then forward it to you. At the surrender, the dealer will usually inspect your car for excess damage. For example, if you had a cracked windshield, any larger dents, or a broken taillight, they may charge you for the damage, or they may ask you to get it repaired and to reschedule your surrender appointment. Following the surrender, there's just a couple final steps before your lemon law process is finally complete. For best practice, we recommend our clients fill out a transfer of liability form with the DMV. Most of the time, you fill this out at the dealership during your surrender, but why not play it safe and fill it out again? This lets the DMV know that you don't own the car anymore, just in case it's involved in an accident after you give up possession. And the last thing you need to do if you had a loan on your car is to follow up with your bank. You want to make sure to double check that they got payment from the manufacturer. Depending on the terms of the settlement, you may be getting an extra check back directly from the bank for any payments you made after signing the settlement agreement. And now the biggest problem I see people make is rushing their lemon law claim process. For the love of God, please be patient. Don't get me wrong. I know exactly why it's not easy to be patient. You're paying a ton of money for a car that's not working. Maybe the dealership isn't giving you a loaner, but the car manufacturers are banking on you tiring out. It takes time for us to build pressure in your case to force the car manufacturer to do what we want. And you have to give us time to cook. At the end of the day, we work for you and we'll be respectful of your timing. And there you go, the all new 2025 California lemon law process from start to finish. I'll be pumping out videos all year covering each of the topics covered in this video in much more detail. So make sure to subscribe to stay in the loop. Don't forget to leave a comment with any questions or suggestions for future topics, and check out one of these other videos for more on the lemon law.